Today we are continuing our discussion on end-of-life care. Previously, we discussed ordinary versus extraordinary care, but today Dr. O'Connell will be discussing legal documentation and healthcare planning. And our final show on end-of-life care will cover organ donation. And as an aside, if you missed our last discussion, you can go to our website at catholic540am.org, click on the Listen tab, and scroll down to local programs. Just click on the icon for Dr. On Call, and you'll see Dr. O'Connell's shows there, excuse me. So Dr. O'Connell, legal documentation, and I have to admit, I personally was very confused about what was out there. So I'm really looking forward to this discussion today. Now, I understand that there are three very important documents relating to end-of-life care. What are they?
Yes. So the three documents are the healthcare power of attorney, the advance directive, or sometimes called a living will, and the third one is the MOST form, which is an acronym for medical orders for scope of treatment. So those three.
Okay, advance directive or living will are one and the same. All right, why don't we go through each one and you can describe what they do. Let's start with the healthcare power of attorney. And does it have a different name in North Carolina?
So the healthcare power of attorney, North Carolina might have a particular name for it, but that's kind of the common, or a healthcare agent or healthcare proxy or other descriptors that you'll hear for it. So the idea of this one is that normally I would make my own medical decisions. I would talk to the doctor. We would talk about what's going on. They would give me the options of what my treatment choices would be, and I would think it over, and I would say, here's what I want to do. So the issue, though, is what if I'm in a situation where I can't speak for myself because of I'm unconscious, or there's a cognitive issue or a brain injury or whatever the case may be? How does that decision making happen? And so the healthcare power of attorney provides a legal document through which you can make it really clear who your decision maker is. So there's a natural succession in North Carolina, as there would be in most states, where it would fall to a person's spouse, and then I think it's adult child. Beyond that, I don't remember. But you could pick whoever you want to be your legally designated healthcare decision maker. So I could say, I want my spouse to be first in line. And then second in line, North Carolina's document, you can pick three in succession. You could say, number one, I want my spouse. Number two, I want my younger son who has some medical background. Number three, I want my brother. So you could pick whoever you want. And then that person, if you're incapacitated, or if I were to become incapacitated and unable to make my own decisions, that person now takes over as the legally designated decision maker. And if you can't get in touch with the first place person, they go to the second place. And if you can't get in touch with that person, you go to the third in succession.
Gotcha. Okay, now on to the living will or advance directive.
So this is a document that seeks for you to look into the future and make medical decisions now that you would want to apply if certain situations come to pass. So with North Carolina's document, and there'll be some variations on this one, but with the one that is officially what the state legislature has provided, it says, if any of the following three apply, and I get to check which ones I want to apply. If any of the following three apply, if I am dying, if I can't communicate my wishes, and I am dying, permanently in a coma, or have advanced cognitive impediment, which particularly means Alzheimer's disease, then this document comes into force. And then here are the specific things that I want. And so you then initial that either life-sustaining measures may be withdrawn, option one, or option two, they shall be withdrawn. The second category is, you say, artificial nutrition and hydration can be continued or shall be stopped. So it's a document that in the idea of it, it's helpful because it tries to prepare for that circumstance where the person can't speak for themselves. But I will say, from a Catholic standpoint, it's a very problematic document because, like we talked about last time with proportionate and disproportionate care, you have to take in a lot of information to weigh out what kinds of medical care really am I obliged to do in the course of taking care of myself and in the course of upholding my God-given dignity, and what medical care is optional, that the care that is disproportionate or extraordinary is optional. I don't have to do it. I'm not falling short in my responsibility to myself. But you have to have the particulars of the situation in hand to make that assessment. So the problem with the advance directive is you are directing in advance, well, here's what I want done. But practically speaking and morally speaking, there's always 1,001 considerations that you didn't consider. And it's like, well, what if you were going to be on the ventilator for a week? What if it were a day? What if it were a month? What if you have a 2% chance of recovering? What if you have a 20% chance of, like, you need all that information to make your decisions. And so trying to make those decisions in advance and limit the care that you might receive potentially creates a situation where medical care that would be morally assessed as ordinary or proportionate, and therefore care that you really ought to do, you need to do, morally speaking, well, you have pre-decided you're not going to do it. So it's a problematic document. So that's the advance directive, or the living will, as they're sometimes called.
Yeah, I have some questions about that. Let's get through the most form first, and then we'll come
Yes.
back to my questions. Okay, so
Yeah.
what is the most form?
So the most form, this one's a little different. This is not a legal document. This isn't one that you do with your lawyer as you're updating your will and estate planning. This is a medical order. That's the M and O of most. Medical order for scope of treatment. So this is a document that most commonly is seen in like a nursing home setting, for example, and it is signed by the healthcare provider. And it stipulates care in 4 different areas. So first is CPR, yes or no. Second is sort of what level of hospital care to give, whether full on everything or medium amounts of care, like go to the hospital but avoid the intensive care unit. Or third would be no hospitalization. The third category is whether to use antibiotics or not. And the fourth category is artificially provided nutrition and hydration. So all of these things get spelled out and assigned again ahead of time. So that's the most form. One other issue with the most form. So not only does it bring in this concern about making decisions ahead of time, which is inherently problematic, it also trumps the healthcare power of attorney and trumps other legal documents the person may have put in place.
That's really interesting. How can a non-legal document trump the healthcare power of attorney?
Right. But that's what's written into the statute. So.
Very, very interesting. Okay, so you have 2 documents that are done in advance of whatever circumstances you might be going through so many years down the road,
right.
with a ton of different variables. So what is your recommendation to your patients?
So what I recommend to people is, if there would be, I mean, by default, a person's spouse or adult children will be the spokesperson if a circumstance should arise. And honestly, in most circumstances, that's fine. That works. But if a person is looking at doing some legal document preparation, my advice to people is pick a healthcare power of attorney, give them leeway to make whatever decisions that need to be made, and stop there. So I generally, I advise against the most form because of its problematic pre-deciding nature. And honestly, the same thing with advance directives as well. So my advice is healthcare power of attorney. That provides a clear line of succession of people who you wish to entrust your care to, should need arise. The person who can take in all the info, hear all the particulars of the situation, who knows you, and who can speak on your behalf. That's what you want for making those kinds of decisions.
Okay. And is it relatively easy to change should something happen to the person that you've designated as your healthcare power of attorney?
So you can update it. I mean, it's like with lots of legal stuff, you can strike a line through it that says no longer valid.
Okay.
But also with North Carolina's, you can pick 3 people in first place, second place, third place order. So if something happens, let's say your first place person moves away, whatever, says, I don't want to do it anymore, you don't even necessarily have to redo the document. It just is now going to go to the second place person that you had designated.
Okay. Okay. So again, Dr. O'Connell recommends just doing the healthcare power of attorney.
Right.
Okay. And I know that you mentioned before, and we talked about this prior to this interview, that the Diocese of Raleigh has their own document
Yes.
for Catholics in the diocese. Why don't you talk a little bit about that?
Yeah, so this is very helpful. If you don't necessarily have a trained bioethicist, living in your house, then it's the diocese provided resources for folks to try to make it easy. So if you go to your search engine and search Diocese of Raleigh, Advanced Directive, so they use the term that people know, Diocese of Raleigh Advanced Directive, it pulls up either a document or the webpage, depending on which search engine you use. So the first 8 to 10 pages of the document just sort of explain the issue. So if you want to learn a little bit more without going super deep into the weeds of it, it gives a good basic framework to think about this. And then the second half of the document is actually a legal template. So you designate your healthcare power of attorney. I talked to one of the lawyers who was involved in it, and they wrote it up very carefully. They wrote it in such a way that it would meet the criteria of all 50 states for portability. So if you are on vacation out in the Rocky Mountains and something happens and your healthcare power of attorney has to come into effect, your document is legal in Colorado, for example. So it has a healthcare power of attorney. It has some language that very clearly stipulates a Catholic approach to care at the end of life, like saying food and water are, as a starting point, to be done unless there's some compelling reason not to. So it addresses these things in a way that is accessible to the layperson, meets 50 states requirements, and has a Catholic disposition to it. So I think it's a very good document.
Yeah, I've looked over it as well, and like you said, it has an educational section, appoints a healthcare agent, and it addresses life prolonging measures while avoiding many problems in a typical living will.
Mm-hmm.
Got a section on pregnancy, disposition of remains, and like you said, it upholds a Catholic approach to the goodness of life. It's a fantastic document. So I highly recommend listeners to check it out. And you can Google it again, Diocese of Raleigh Advanced Directive. Okay, we have some questions from listeners. I'd like to touch on those a little bit. What restrictions as a Catholic should you put on your healthcare power of attorney?
Yeah. So in general, I would say give your healthcare power of attorney leeway to make decisions. I suppose if there was some issue where you thought, I'm not sure they're going to know the Catholic thing with this particular topic, maybe you put some stipulation in. But as a general principle, give them decision-making power. Let them hear out the circumstances and make the decisions about what should be done. That's generally the easiest.
Okay. Next question. Are all documents once signed and notarized binding forever? Do they need to be redone?
So they can, yes, that's a great question. You can revoke any of these as soon as you're ready to. If the person has an advanced directive and says, wait a minute, I just heard on Catholic radio, I shouldn't be doing this. It just write a line through it and say, write void. That's it. You're done. It is now no longer in effect. So yeah, these are all revocable, redoable, whatever you need to do.
Okay. Next question. Where do we get the forms?
So depending on what your form you're looking for, if you do a search for North Carolina healthcare power of attorney, you can pull up a document. Lawyers' offices have templates of these documents on hand, and the one for the diocese. So if you do a search for Diocese of Raleigh Advanced Directive, some search engines pull up the document itself. Some of them pull up the page on the diocesan website where the document lives.
Okay. Okay. And then the next question we've already touched on when do these documents go into effect? You had said when you become incapacitated with the healthcare power of attorney.
Right.
Okay.
And that's an interesting point. I mean, I have like sometimes in the office, I've encountered a situation where a family member of someone in the practice says, "Oh, hey, I need to, get some info about my mom," and I'm like, "Well, but I don't have a release to give you that information." And they're like, "But I'm the healthcare power of attorney." I'm like, but your mom is competent. So the healthcare power of attorney, it's just waiting in the wings. It's not active right now. So until a person becomes incapacitated, healthcare power of attorney, advanced directives, these don't come into play.
Gotcha. Okay. For the healthcare power of attorney, whom should we choose?
That depends on you and your discernment process. Yep,
Okay.
definitely.
Now, what about additional resources? People are listening and they want to get some more information on this and educate themselves. Where, besides the Diocese of Raleigh's advanced directive, where
Yeah.
would you recommend they go?
Yeah, so a couple of options. So one is a great organization, the National Catholic Bioethics Center, which is a very faithful Orthodox organization that has both a teaching mission as well as a advising and support mission. So their website has a lot of great information. So ncbcenter.org, National Catholic Bioethics Center. Um, so there's a lot of information you can get there. If you really want to dig into it in more depth, there's a very good book by an author, William May, who's a Catholic, now deceased Catholic moral theologian and bioethicist. His book is Catholic Bioethics and the Gift of Human Life. It is written at a level where you can really get some depth, but you don't have to be a theologian, a formal bioethicist. As a lay person, you could read it and get it. So it's good. So if a listener has interest in kind of digging a little bit deeper into it, that's a great resource. It's hard to beat. Um, and then as a third one, this is way more like view from 30,000 feet. But John Paul II's encyclical, The Gospel of Life, Evangelium Vitae, just a tremendous and soaring affirmation of the goodness of human life that God has given us. It doesn't get so much into the nitty gritty of this document versus that document for your healthcare planning, but it provides that framework that at its heart, life is good and is a gift from the Lord.
Very good point. And we can spend hours and hours and hours talking about the gospel of life. So,
Mm,
not even with end of life care, I think it's a
right.
worthy study at any time
Yes.
that can be picked up. So,
Yep.
again, just to reiterate, the Gospel of Life, Evangelium Vitae by St. John Paul the Great, Catholic Bioethics and the Gift of Human Life by William May, and checking out the National Catholic Bioethics Center, ncbcenter.org. And Dr. O'Connell, I have to tell you, I reached out to them about 15 years ago, and they were tremendously helpful. Had a
Mm,
family member that was passing away. He had, I think I've talked about him before on the show. He had muscular dystrophy Duchenne's and was in his last months. And some of the issues that were presenting themselves really concerned me. So they were incredibly helpful. So I highly recommend them.
mhm.
Okay, as we come to the end of this show, I wanted to say we're going to be talking about vaccines next time. It's such a timely topic. So we're going to
Mm.
interrupt our discussion here on end of life care, and we'll do vaccines in January. And in February, we'll talk
And
about,
COVID vaccines specifically.
I'm sorry, yes, COVID vaccines, right?
Yes.
We're hearing a lot about AstraZeneca and Janssen and Moderna and Pfizer.
Yep.
I've had several people, list what their concerns are with the efficacy of the vaccines and
Hmm.
um, getting a lot of mixed messages. Surprise,
Hmm.
surprise, in the secular media. So it's a very timely topic, and I'm really looking forward to
Yes.
that discussion. Um, okay, so final thoughts on end of life care legal documents.
Yeah. So the one last thing I would say is oftentimes when people are being responsible and go to their attorney to do things like updating their will and just getting all that stuff in place, as a convenience, very often attorneys will build into an estate planning document an advance directive component to it. And so you're reading along about, what's going to happen to the car and the furniture and all that. And then there's this thing that says, do you want tube feeding, and what about life-sustaining measures? And just realize, like, oh, that's what this is. This is an advance directive. So that's one where if you should happen to encounter it, realize that's something that may happen, and you don't have to sign it. You just say, no, I'm not going to do this. I have a healthcare power of attorney. Or say to the lawyer, hey, can we do a healthcare power of attorney? Because I know who I want. So.
Yeah. Okay. So pay attention to the documentation that you're reviewing with your lawyer about estate planning.
Mm-hmm.
It's a really good point. Okay. And I think this is a really good thing to bring up. You had mentioned in past interviews or presentations that you've done on end of life care about the statue of Jesus at the hospital where you did your residency in Baltimore. Why don't you end on that?
Yeah. I love this. So I did my residency at Johns Hopkins Bayview Medical Center up in Baltimore, and the old Johns Hopkins Hospital, which is now one of the administrative buildings. The old Johns Hopkins Hospital is this beautiful Gothic building it's very beautiful. Big dome in the center of the building. And as you walk in, that was the entry to the Johns Hopkins Hospital back in the day. And as you walked in, there was a statue there that is apparently a recreation of a statue in Europe somewhere of Jesus. And as you come in, it's like, oh my goodness, this twice 1.5 life-size time statue of Jesus with his hands outstretched to the person walking in. And as the statue stands on the pedestal, one foot extends just past the edge of the pedestal, so the toes are sort of free in space, and the big toe on the statue had been rubbed smooth by all the people over the many decades who had come in and touched the foot of Jesus, the statue, as they came in, for comfort, because they're coming to see family members who are ailing in the hospital. And the words of the statue are just so apropos of end of life planning. It's the scripture verse that says, "Come to me, all you who are weary and heavy laden, and I will give you rest."
Very well said.